Okay.
Good afternoon, everyone. I think you should all be here now. I'm going to make a start, and then, of course, if anyone else joins, of course, they can then pick up on it as we go along. The presentation that I'm going to deliver will also be emailed to you along with the handout. So don't worry too much about taking any notes. I mean, you can if you want to, but not only will the PowerPoint be there, the handout, which is far more detailed and covers everything I'm going to speak about, will also be sent out to you after the seminar. This afternoon, we're going to talk about what good practice will look like when it comes to the issue of domestic abuse in care proceedings. To better understand this issue, though, we're going to try and cover three particular areas. We're going to try and understand and get a full sense of what domestic abuse can mean and the way it impacts on individuals in our society. We're then going to look at how it relates to the justice system, what measures there are in place, in particular in the family courts, to assist with this issue. And then I'm going to go through some relevant case law with you, both in terms of care proceedings and published cases therein, but also we're going to look at some of the private law cases because they tend to deal with domestic abuse more readily when it comes to published judgments. So what is domestic abuse? Now, as care practitioners, we all have a sense of what that involves, and more or less we'll have a good idea around it. I think it's right, though, to get an idea of how it is defined. CAFCAS, in their guidance online, will say that domestic abuse, they take the government's guidance, and by that they mean the guidance from the 2021 Act. And they say that domestic abuse is any incident or pattern of incidents of controlling, coercive, threatening behaviour, violence or abuse between those aged 16 or over who have a relationship with each other. They say that it can be psychological, physical, sexual, financial, emotional, and it can be other things as well. I think it's important to note that there is an other abuse that it can be, because it isn't clear, or purposely, whenever anyone else has tried to define domestic abuse, they've kept it wide and has not limited it to set types of abuse. So the Domestic Abuse Act 2021, which is where CAFCAS has taken this definition and the way they work, has defined domestic abuse, created a statutory definition for it. And they, like we've learned from CAFCAS, say that it is behaviour, domestic abuse is behaviour of one person towards another, and can be any of these things: physical, sexual, violent, threatening, controlling, coercive, economic abuse. By that they mean financial abuse, psychological abuse, or other abuse. So we always keep that broad heading because of domestic abuse being so complex, and because we simply cannot categorize fully the ways and the nuances around this type of abusive behavior. Likewise, as CAFCAS considers the matter, we also see that the Act in fact tells us that it is between people aged 16 or over, people who have some form of a relationship with each other. I think it's right to say, though, that of course we know that domestic abuse can impact on teenagers. And so when we look at the definition, age 16 or over, that is what the statute says. It might be that there are situations where we see Gillick competent children who are a little bit earlier in years, 15, 14, already starting to end up in abusive situations. The guidance tells us, and if you ever need it, you can turn to it. There is statutory guidance that comes with the Act, and it gives us examples of what abuse can look like. But it also covers more widely some of the issues we're going to talk about today, some of the less obvious ways that we can see abuse, whether that is through social media and the use of technology, whether that is through female genital mutilation, forced marriages, and, as we might know it, honour-based abuse. I will say that we won't cover much of honour-based abuse today because it can be its own seminar. And if it's the kind of thing you want a seminar on, please let me know, because, of course, it's a very serious issue. The Act has set up a system whereby the accused should not be cross-examining the survivors of domestic abuse, the people who make allegations against them. And that applies both in the criminal courts and the family courts. The Act created domestic abuse protection notices and domestic abuse protection orders, both of which have replaced the old domestic violence domestic violence protection orders, the DVPOs. The reason why that was replaced is because, of course, as we know, it only lasted for 28 days. And there were often concerns about how enforceable it was and actually how serious the punishment that followed was. So we now have two new systems in place, the Domestic Abuse Protection Notice and the Domestic Abuse Protection Orders that can be applied for. I'm going to give you a lot of detail on both of these, so don't trouble yourself too much, but I'll tell you now in overview form what that involves. The notice, the Domestic Abuse Protection Notice, is something that can be put in place really quickly, and what it does is it can limit the way that a person has to behave. So the way that they can contact someone else who's named in the notice, whether they can come into a certain distance relating to them, whether it can prohibit them, for instance, from going into certain accommodation. And you can already see by me saying that there is an overlap in these provisions between things like non-molestation orders and occupation orders, which is the go-to typically in the family courts. We now have other ways that can overlap, but also allow the criminal court and the other civil courts to look at and tackle domestic abuse. I think it's fair to say that these types of the notice and the order can also be applied and sought and granted in family proceedings, in civil proceedings and in criminal proceedings. So it's something that's there pretty much before any tribunal to protect people in domestically abusive settings. The Domestic Abuse Protection Order is wider. What it can do is it can prevent certain harmful behaviours, preventing someone from doing something, for instance, or it actually can attach what's a positive requirement, requiring them to do something. So, for instance, requiring them to attend a misuse program, a substance misuse program, something like that. The court can make a domestic abuse protection order if, on the balance of probabilities, it feels that a party has been abusive towards someone and they feel that it's necessary and proportionate to do so. So it is a new provision that is there. It is a new system that has come into place under the Domestic Abuse Act to offer further protection of victims of domestic abuse. The Act was also helpful in that it allowed and brought in a statutory scheme of how Clare's Law could be administered, how people could find out about past convictions with partners. The Act is also helpful because it properly formalises certain duties on local authorities when it comes to survivors of domestic abuse and their children, to make sure that those people in those situations can access the best support they can to break that cycle and to protect children. And I'm going to talk about that in a bit more detail because I think that's important for us when we will be in care proceedings. So in terms of what the Act does, it says that it requires local authorities to grant what are considered the lifetime tenancies. If someone leaves an abusive relationship, they should be entitled to have another lifetime social tenancy in their own name, in a sole tenancy, if in fact they've moved house or they've changed tenancy because they've been a victim of domestic abuse. So it makes sure that people don't feel disadvantaged, don't feel they have to stay in a particular relationship or in a household because they will lose their lifetime tenancy on social housing. The Act also, however, puts certain duties on local authorities, and it puts duties on what we call Tier 1 local authorities. So by Tier 1, I mean county councils, metropolitan councils, unitary authorities, and actually the Greater London authorities, to make sure that anyone who is a survivor of abuse and the children who are with them, if living in a refuge, safe accommodation, sanctuary scheme, second stage accommodation, receive appropriate support. What does appropriate support then look like? Well, appropriate support involves them having things like therapy and counselling to help them to overcome what they've been through, making sure that they can access as much support as they can to try and rehouse themselves, to move on from the halfway house scheme, in essence, the refuges and the sanctuaries, making sure that they can communicate effectively with professionals who can support them, making sure that if they require complex and specialist services, that they are given appropriate support by the local authority to access those services, and making sure that they have domestic abuse work done with them, things like the Liberty Programme, things like ongoing support to help people and children who have suffered domestic abuse not to fall into those cycles again. So if you ever need that in a case, if you have a case where domestic abuse is the crux of the case and you want to make sure the local authority understands what its duties are and make sure the court understands why the local authority should be acting probably in a way that they haven't done previously, then you want to rely on this act to highlight the certain duties that the local authority have, statutory duties to support victims and survivors of domestic abuse. Now that we've touched on the Domestic Abuse Act and its overall statutory definition of domestic abuse, I think a lot of this might have been obvious to you as care practitioners, but there is more to the issue of domestic abuse. And in particular, I think it is important for us as practitioners to understand what the judges are told when it comes to domestic abuse. We hear a lot on the grapevine around judges getting specific training for domestic abuse, that they are being that the steps are being taken to make sure that they're very clued up about this issue. But actually, what guidance do they have to make sure that they tackle the issue correctly? And as we know, a lot of the guidance that goes before the judges and a lot of what they are expected to follow comes from the Equal Treatment Bench Book, most recently revised in April 23, although a further revision is underway and we should have a new version of the book in the fullness of time. So what can we take from what the judges are told? Well, they're told the same things we are around the Act, the 2021 Act, around what CAFCAS defines domestic abuse as, around the fact that there is no definition that limits the form of abuse, but abuse can be very subtle and nuanced. But what they are also told, and what I would encourage you all to incorporate in your practice, is this: we should avoid the term victim when it comes to domestic abuse. Some people will consider that term offensive, and certainly we will think of it as outdated. The idea behind it is that it implies a degree of passivity. It implies that these people are somewhat helpless. And in actual fact, a lot of people who have come out the other side of an abusive relationship will see themselves as a survivor, will see themselves as strong as a result of surviving that. And so we refer to anyone who would be a victim of domestic abuse as a survivor of domestic abuse. A shift in language, as we know, can be important in terms of empowering people to live their lives. We learn from the Equal Treatment Bench Book that sadly women face domestic abuse at a far higher rate than men do. That's not to say men don't suffer domestic abuse, but the statistics overwhelmingly show us that women are the victim of domestic abuse. For instance, the most recent version of the Equal Treatment Bench Book, and it does need upgrading, talks about almost half of the women killed by March 2019, so for the year 2018 to 2019, almost half of the women killed were killed in a domestic homicide. We know that over the last 10 years, up to 2019, an average of 82 women a year were killed by a partner or an ex-partner. So there is a lot of abuse, and very serious abuse, that sadly women face. By contrast, in the year up to March 2018, so 2019, so April 2018 to March 2019, there were only 16 cases where the killer of a man was suspected to be a partner. So you have 82 for women and 16 for men. And so we think about that, and it certainly is serious because it impacts on men, but the statistics overwhelmingly show us that women tend to be the victims of domestic abuse. Why then do victims or survivors of domestic abuse not come forward and try to get support sooner? Well, there are many reasons for that, and what the Equal Treatment Bench Book tells us is that victims may not want to be involved in prosecutions because, for instance, they lack faith in the system, they have fear of the perpetrator, and they worry about the repercussions on them if they were to come forward. The book also tells us that sadly, as a result of cuts, as a result of austerity measures, we are in a situation whereby there is limited support on the ground. And so survivors of domestic abuse can find themselves rather isolated at times. Sadly, during the pandemic, the situation was made much worse, perhaps unsurprisingly so. But what the book tells us is that after the lockdown, there was a 50% increase in calls to the National Domestic Abuse Helpline, and a 400% increase in website traffic to the domestic abuse support services that are out there electronically online. 400% increase. So we know that being at home, not being able to have that escape route, even if it's just for a bit of air or space, or being able to run down the street to your mum or your dad or another family member, has meant that there was a rise in domestic abuse. And sadly, we still feel the repercussions of that now, many years later, certainly in the work we do and the allegations of domestic abuse that will come to the court. There are a number of significant reasons why women don't leave dangerous partners, and the book encourages us not to get into myth culture, so forming certain preconceived notions around why people don't report things, and we will discuss this in more detail. But fundamentally, we have to remember, for instance, that when domestic abuse survivors try to leave their partners, if the relationship is particularly violent, they are at higher risk when they try to leave, and they will be very conscious of that. We have to remember that we have issues such as psychological reasons at play, for things such as their self-esteem and their self-worth having been eroded, which means that they are far less likely to want to walk out of these relationships. We know that, for instance, there are cultural issues that can be at play, which bring a lot of stigma to walking away and separating from a partner. All of these matters mean that there are many reasons why people don't walk away from domestically abusive settings, and we have to be careful not to form preconceived notions when they will make allegations to say, well, you didn't walk away because you are lying about the allegations you're now making. Although it is less common, men do suffer from domestic abuse, and it's something we must remember. And as I said to you earlier, the Act has allowed a situation where special measures will automatically be available now in courts whenever there are allegations of domestic abuse. Just coming back to the point I made earlier about why people don't leave these relationships, I think it's also important for us to understand and link domestic abuse with issues of intersectionality, because perhaps unsurprisingly, people who have protected characteristics, and certainly multiple ones that may mean that they fall under the umbrella of intersectionality experiences, they are far more likely to suffer domestic abuse, and they are far more likely to be unable to break out of that cycle. The book tells us that disabled women were already twice as likely to be subject to domestic abuse, and actually it got worse in the pandemic. The book tells us to be careful with women who have uncertain or limited immigration status, because, for instance, they may not have recourse to public funds. The problem with that is they can't then, they're not eligible for things like refuges and the opportunity to break away. We know, as I've said earlier, about cultural, religious and social stigma that can follow. We know that there is a culture, or there are cultures where leaving a man or leaving a partner to be on your own, or to be a single parent, can come with stigma, can come with shame. We also know that in those situations, honor-based violence might play a part in what happens next. If you leave, you are bringing shame on the family, and there are implications to that. And we have to be very alive to that when we have survivors of domestic abuse coming before court. We have to understand that at times people can stay in relationships because leaving may dissolve their support network, whether that be due to distance or family connections. We have to understand that there is still a culture of the older generation saying at times, not to everyone, but in some cultures, you have to stay and make your marriage work. Your marriage is really important. There's a certain level of pressure to live up to that. And of course, it will not be lost on those who attended this seminar that if you don't speak English, you may struggle to access support and be able to speak up and to get out of an abusive situation. Those with intersectionality issues, whether they be certain cultural issues, whether they be disabilities, can find that the situation is far more compounded for them. And the book doesn't specifically address this, but I invite you to think about actually bearing in mind what we know of intersectionality issues. In our practice areas, might we need to be conscious of that when we will work with members of the LGBTQ plus community, who may themselves be quite vulnerable to abuse, and the young adults, the people transitioning, the 14 to 18-year-olds who we will work with in the care system, who have suffered abusive childhoods and might, as a result of that, be more vulnerable. I group these people together. I group the queer community and young adults with abusive childhoods together because there's something they share, I think, in common. That means that they are more vulnerable. In particular, if you come from a LGBTQ plus background, where you were not accepted in your childhood, and again, intersectionality issues and cultural issues will be relevant here. You may then, if you were rejected, if you were ostracized, you may well crave a certain level of affection and love and care. You may well normalize having been rejected and treated awfully and believe that that is the way relationships are meant to work, which makes you far more vulnerable to ending up in a domestically abusive setting. Likewise, young adults who have suffered abusive childhoods may well normalize and believe that that is what adult relationships are meant to be like, and that is the love that they deserve. And I feel that that makes them far more vulnerable to being exploited when it comes to partner relationships. We need to be alive to that when we will work with these young people. We need to be alive to that when we will work with these members of the queer community and do our best to make sure that we stand up for them. What do the statistics show us then? I've told you a little bit about the statistics that we've seen in the Equal Treatment Bench book. Now, if we were to bring it up to date, because 2019 is a long time ago, has the situation gotten any better? Well, the Crime Survey for England and Wales estimated that 2.1 million people aged 16 years and over experienced domestic abuse in the year ending in March 23. So 22 to 23, we had 2.1 million people who have suffered domestic abuse. And in particular, sadly, the numbers remain particularly high for women: 1.4 million women, 751,000 men. There were 51,288 domestic abuse related prosecutions in the year of March 23, compared to 53,000 in the year ending 22. So not only have we prosecuted fewer of these offences, but compare that to the amount of crimes that have been reported to be committed: 1.4 million for women, 751,000 for men. Only 51,000 actually resulted in prosecutions being taken. And of that, an even smaller number actually resulted in convictions, 39,000, which sadly means that there is a lot still for the system to do to try to improve the situation for survivors of domestic abuse. Now, we know that these statistics will be influenced by things like the reticence to come forward and stand up and support prosecution, the unwillingness to separate from a partner. But sadly, the situation still remains quite dire when one is to look at the situation on the ground, and when one is to think about the safety risks to the people we will work with in the family system when the conviction rates are so low and even the prosecution rates are so low. If we were to think about the impact that those low figures will have, let's say someone comes forward and speaks about the abuse and expects and hopes that they will be given the opportunity to have a fair hearing that will result in a prosecution, that they will have their opportunity to explain what they've been through and see some justice done. Well, the reality is when the numbers are that low, when actually the police, the CPS are not able to prosecute as many crimes, or when the conviction rates are incredibly low, we're left in a situation where, as Dr. Jem Tosh, a chartered psychologist in England, has said, not being believed can exacerbate existing trauma by increasing shame, preventing further disclosure, and it can lead to an avoidance of support services. It can result in a survivor feeling like the abuser's perspective is valued more than theirs, that their pain is considered irrelevant or invalid, and like they have to suffer in silence. When the young people we will come to work with, and I say young people, I mean the young adults, but I also mean the clients, the parents we will work with, come to court and they don't feel heard, when they will feel as though they're not being taken seriously, when the police have NFA'd what they've said previously, you might find that they don't wish to relive this, that they are unlikely to support the matter being taken further, even in the family courts. And this is why it is around the traumatic effect that it can have, and the fact that they may not feel heard or valued in the same way as the perpetrator. So that gives us a nice sense, I think, of what domestic abuse is, how different agencies and the statute defines it, and the kind of things that we need to be aware of, that judges are going to be aware of in terms of domestic abuse, the wider issues, the context of what goes on in the ground, including things like the prosecution rates. Now I want to turn to some more specific forms of domestic abuse, which you may or may not come across in your practice, but actually I don't think they're talked about enough. And so we will turn to them to get a better sense of them. Let's start with sexual offences, one of the biggest areas of domestic abuse. Sadly, again, we're in a situation where there are lots of people who have been the victim of sexual offences in a domestic abuse context. So according to the Crime Survey for England and Wales, approximately 16.6% of adults and over 16, age 16 and over have experienced sexual assault since the age of 16. So we're talking about a lot of people here. We're talking about 7.9 million people have experienced a form of sexual assault, and 1.9 million of them were victims of rape. 7.7% women and 0.2% men. I should say there, the astute lawyers amongst you will already say to me, well, the law doesn't let men get raped, and that's right. In criminal law, you can't rape a man, but of course, when we look at these statistics, the way the definitions will be formed will be around non-consensual penetration. And so we don't stick to the criminal definition. And in fact, I will later refer you to a case where it is said that we shouldn't look at criminal definitions. We should instead focus on what we see as a wider canvas in the family court. In March 2019, the government published its first ever position statement on male survivors of crime, though. And I think that's important for us to note that actually, even though these numbers show us an overwhelming sense that women are the principal victims of domestic abuse, the numbers of men who are suffering and who are survivors of domestic abuse is slowly rising, and it's very worryingly rising. And what the position statement that was published said was, look, the reality of the situation is men are suffering abuse too. And not only are they suffering abuse, but we have to be conscious of why they're suffering abuse. We have to recognize things like harmful gender norms, which I will call male toxicity, shame or honor coming into place, stereotypes of what masculinity and sexuality should look like. And each of those things, A, can cause or be an underlying contributor to domestic abuse, but B, can prevent men from actually coming forward and reporting crimes, can stop them seeking support. We need to be breaking down these barriers and making sure that our clients understand that these are not the kind of things that they should be focusing on. That is wrong, and if they have suffered, they need to speak up, and they also need to seek support. That is very important. We know that in sexual offences, young people are disproportionately affected, females and males. And we know that sadly, fewer than 1 in 5 people who have been raped or sexually assaulted actually report it. And again, that part is in the Equal Treatment Bench book. So if you want to flag to a judge that you are presenting a rape case into, that in fact, the fact that the complainant didn't report it very quickly after the incident is evidence, is not evidence of dishonesty, then you want to turn to the Equal Treatment Bench book and show them the fact that it is recorded. 1 in 5 people don't actually report it at all. Which brings us nicely on to rape myths, because the Equal Treatment Bench book, and again, this section comes from that, so please, if you need it, refer to it. A judge will listen if you refer to the Equal Treatment Bench book. They should be following this. Rape myths play a big part still, sadly, in what the system says and how we look at things, and we need to work together to disband that. The High Court, in the case of A and others and B and others, specifically brought focus to the Equal Treatment Bench book and brought focus to the gender section, which is the section I am referring you to, and talked about the different range of myths that sadly still exist and sadly will be looked at and used as I want to say defences, ways of discrediting complainants of domestic abuse and rape in particular. So what are some of these myths? Well, the myths can be, for instance, that rape complainants are common liars. The CPS, in fact, has said, look, actually very few people make false allegations. And as we've already discovered, only 1 in 5 people actually come forward. So it's hardly the case that rape complainants come forward readily to lie. If the complainant has previously alleged a different rape, then there might be a suggestion that she's now lying. I think that shows on many levels a certain level of naivety. I have the benefit, I would say, in this particular situation of being trans, which means that I lived until I was about 21, 22 as a boy, and then transitioned into a woman. I think there is one of the things I learned on my journey was around exactly what hardships women face. Because when I got to the point where I passed well, and most people in society assumed that I was just a cisgender woman, then all of a sudden I can say, hand on heart, the instances of me having been spoken to inappropriately by a man or touched inappropriately in a nightclub, etc., shot up through the sky. And it really surprised me through my own lived experiences just how dangerous the world can be for women, and just how awful it can be, and the lack of boundaries that certain men can ingrain in them when it comes to their treatment to women. A woman might well report more than one type of rape. A woman might well report more than one sexual assault. And that is because, sadly, women live in a society where we all have, I will confidently say, at least one story of a man behaving sexually inappropriate to us. Whether that's something as simple as touching our bum when they walk through a nightclub with us, rubbing against us when they walk through a bar. We all have a story, at least one story to tell. And that to me says, quite rightly, that this myth that because you complained about something previously is evidence of you being a liar is entirely wrong. Because the reality is we live in a world where women are at greater risk of domestic abuse and rape. And it may well be that, sadly, vulnerable people might find that they are in situations where they can be multiply exploited on multiple occasions. Another myth is that rape is an easy allegation to make. It's not easy at all. In fact, many complainants of rape talk about a feeling of lack of support. There's so much on social media at the moment against women, saying that women make up rape allegations to control men. It's not something that's easy to come forward with. And often when women come forward to make these allegations, they find that a lot of people turn on them and assume that they are liars. Rape by a former partner or a husband is not really rape. I'm not going to go into that. We all know that that is wrong. Um, Sex offenders are different from ordinary people. And of course, we know that there is no way that a sex offender looks or acts that means that it's obvious that they are a sex offender. We work with people in the family justice system all the time who we might be surprised from how they behave and act that they end up with findings of sex abuse against them. There is no way for people to look. Kissing is not consent. It's not consent for sex. The complainant's clothing, entirely inappropriate. Lack of injury or torn clothes. Well, again, that shows a lack of understanding and appreciation around the fear that is felt when someone violates your personal space and body. And often being paralyzed is quite a normal reaction in that setting. It is also the case that that shows a lack of appreciation for the sense in that context that women feel of the imbalance of power. Can they actually stand up and fight this man? Will they be killed if they try? Is it worth, in fact, lying there and taking this awful, tragic incident as the only means to protect yourself as best you can? And so there are obvious myths that we need to dispel, and we need to call out when other people will try to use this by way of cross-examination of vulnerable complainants. Further myths, for instance, the lack of immediate complaint means it didn't occur. And of course, we know that a lot of people try to make sexual history and someone being somewhat promiscuous a reason to show that it might not have been a rape. We know that is wrong. So when it comes to sexual offences, there is a lot of guidance. What I would say to you is there's a lot of guidance from the Equal Treatment Benchmark of the kind of myths that we need to be dispelling. And if you are representing someone who is making complaints of rape and sexual abuse, please direct the judge and the court to this section in the Equal Treatment Benchmark if those tactics are being deployed by way of defence. It should certainly not form part of cross-examination, and it should be something that you flag to the judge as soon as possible. Let's move on to the next type of abuse that I want to cover briefly, and that is online abuse. We know that we live in an era now in 2024 where everything is online. And most of us would have caught up with that, although maybe not all of us, because I'm still not fully there with Instagram. Online abuse is really common, sadly. Anyone that's on Twitter will have no doubt seen the high levels of abuse that we come across daily. And in particular, studies have shown that the level of online abuse is again overwhelmingly towards women. It is gendered abuse is how it's referred to often. That isn't, again, it's not to say that men don't suffer abuse, but it appears to be that the keyboard warriors are far more willing to tackle and insult women. And more recently, from my experience, trans people get a lot of attack online, perhaps as a reflection of everything else going on in the media at the moment. So we need to understand the different types of online abuse that there can be, and to better understand what we should be pleading on behalf of our client, what we should be advising them about, and what we should be recognizing when we will look to form and show the court that there's a pattern of coercive and controlling behavior. We have, for instance, hacking into and controlling someone's social media accounts. That is considered online abuse. We have gaslighting. Now, I don't know if anyone knows, or doesn't know, I should say, what gaslighting is, but to assist you, gaslighting is a form of psychological abuse. It's really psychological manipulation, where you try and convince someone that what they say happened, the abuse that they have suffered, the trauma that they have suffered, never actually occurred. So you're trying to say to them, that actually your truth is not the truth. You're trying to convince them that they have it all wrong in their head. And it is something, surprisingly, that happens all the time, where people say, that never happened. You're making that up. I never shouted. I never swore at you. What are you talking about? And they know fully well that they've done that, but it then is playing a psychological game with the other person. We have another form called sextortion, which is the use of images online, to sexual images, nude images, to try to extort money out of someone, and that's called sextortion. We have revenge porn, which I think speaks for itself, but it is, in essence, when someone has sent you some material, some private nude material, for instance, of themselves, and they only consented for you seeing that. So they sent it to you very much on the understanding that only you would see it, and then you then use that and expose it to the wider public, send it around to family and friends as a way of degrading that person and violating their privacy. That is considered a form of online abuse, online domestic abuse. Virtual mobbing or dogpiling, which is encouraging people to abuse someone online. We have trolling, which is sending people lots of nasty messages, commenting on things in a really abusive way. So, for instance, trolling would be saying to someone, go kill yourself, you're worthless, which sadly we see so much of online. Creating fake accounts, stealing someone's identity, hijacking their accounts. Posting photoshopped images on social media of a person. So we recently saw this with Taylor Swift, and people posting images, photoshopped nude images of Taylor Swift online, which in itself can be a violation of someone's sense of identity. Baiting or humiliating people online in comments you'll make and in forums. And also, as I say, posting things online, which is almost indirect, but is enough to make that person feel violated, like posting images of their place of work, posting images of where their children go to school. Sadly, that does occur. And spamming, which we're all familiar with, sending multiple junk emails and viruses to the person. So as a whole, all of those things we need to be aware of, because they can be forms of online abuse. And as I say, sadly, it is more of a gendered issue because it seems to overwhelmingly affect women and girls. Of course, we have our family court protections, and we've covered some of that already, but to repeat, non-molestation orders, occupation orders, and of course the new domestic abuse protection orders. But there are other protections out there for the victims of domestic abuse, and you may find that in family cases, you might have to say to your client, it's not something I would advise you to pursue in these proceedings, or the court has decided it's not proportionate to deal with these issues in these proceedings, but I would advise you that there are other forums that will allow you to have certain protection. Of course, the obvious one is to report it to the police, get the police to step up and do something. But if that doesn't result in something happening, there are certain protections, in particular for online abuse, that I would flag. So the Communications Act 2003 created an offence of sending, causing to be sent by means of a public electronic communications network a message or other matter that is grossly offensive or of an indecent, obscene, or menacing character. Section 33 of the Criminal Justice Act 2015 makes it an offence to share private sexual photographs or images with the intent to cause distress, and that includes the threats to do so as well. And the Protection from Harassment Act 97 provides for civil remedies. We know that that is your civil restraining order that is available to someone. Let's talk about another form of abuse that is becoming something that is more and more recognised, and it is coercive and controlling behaviour. It is a criminal offence. The Serious Crime Act 2015 talks about this, created an offence. It is a pattern of behaviour, so it's not just one incident. It's you behaving in a certain way, which then repeatedly and continuously has a serious effect on the victim. So quite vague, quite large in the criminal sphere to try and catch this. We do have some guidance on what this can look like, and so I've given you that here. We have the isolating a person from family and friends, depriving them of their basic needs, monitoring their time, monitoring online communication. I won't go through all of these, and I don't want you to worry too much about writing this down because, as I say, you'll get the handout. But there are lots of ways that a person can control. And the thing to understand about coercive and controlling behavior is that it is different from other forms of abuse. Rape, serious violence, they're obvious forms of abuse, and one incident is enough to be able to demonstrate serious and significant domestic abuse. However, coercive and controlling behavior is different. It might be part and parcel of coercive and controlling behavior, and that's how rape occurs. But actually, coercive and controlling behavior can be established on a lot less. It can be minor incidents that by themselves may not look like abuse, and one would think, actually, this is nothing. But it's the combination of them, the cumulative effect, that means that this has now become that means that it crosses the threshold into domestic abuse, and it has now become a recognized form of abuse, because it has a debilitating effect on individuals when they receive these things cumulatively over a longer period of time. So, for instance, lots of spamming, lots of abusive emails, lots of trolling online can end up being coercive and controlling behavior if it is between related individuals over the age of 16. So that's something that we need to be aware of, and I will come back and speak about that in more detail. Let's move on for a moment, though, on female genital mutilation. We spoke a little bit about this at the start. I think, again, I would flag that this because it's a very real issue. Sadly, there are 137,000 women and girls affected by FGM in England and Wales, which is quite a lot of women in England and Wales. And in the world, the situation is pretty dire. We still have 200 million girls and women alive in 2020 who have been cut. That is a very sad situation because we know that FGM isn't something that is done for any benefit. It doesn't increase fertility, it doesn't improve hygiene or any of those sort of things. In fact, it can cause lifelong issues for women, including but not limited to medical issues, health issues, but also psychological issues. We hear that there are cultural reasons or religious reasons for doing this, but the reality is it is a criminal offence. It is considered mutilating another human being. And if that comes up in any of our cases, of course, we know that we can seek female genital protection orders under the FGM Act 2003, which allows, and again is very wide, it allows for such prohibitions, restrictions, or requirements, and such other terms as the court considers appropriate. So it may relate to conduct even outside of England and Wales, saying that this should not happen anywhere, or it may relate to conduct in England and Wales. And it is all about protecting young people and making sure that vulnerable people in domestically abusive settings receive proper support. By the way, I should say with the FGM orders, it is right that someone can either apply for it or the court can do it of its own motion. So if it comes up as an issue relatively urgently in your case, and you think, gosh, we need to do something about this today, you can seek those orders on the hoof. Likewise, forced marriage, a very real issue, a very cultural issue, but something we need to be alive to. And I've included there the Forced Marriage Civil Protection Act. That is open to people of all ages and to make sure that they are protected. Breach of the order is a criminal offence, and what the order can do, if you seek one, is to prevent a marriage, annul a marriage, stop someone going outside of the jurisdiction if the intention of it is to marry them off, and to assist with that, forcing them to surrender passports. So it can be used against a parent to stop, for instance, a young adult getting married. If you are needing to go down that path, the main case on it is the Reagan case. So now that we have that really wide understanding, not only of domestic abuse and its definition, but how the court should be looking at it and different specific areas of abuse in more detail, let's turn specifically to it in care proceedings, domestic abuse in care proceedings. I think it's fair to say that sadly there is discussion out there to reflect that in fact the care system it's failing survivors of domestic abuse. In particular, I flag to you this particular quote that I would ask you to think about. To assist you all, Olga Borzova presented this report, The Social Services in Europe, Legislation and Practice of the Removal of Children, to the Council of Europe, so the Parliamentary Assembly and the Council of Europe, to highlight some of the difficulties. And there she specifically flagged the situation in the United Kingdom. What she was saying is actually mothers who are victims of domestic abuse seem to be re-victimized by the child protection system, because what we tend to find is that women face a very different, difficult option. They face the option of coming forward and saying, I'm in an abusive setting, I am suffering here, and risking social services stepping in to say, well, why haven't you protected your children? What have you done? Can you look after your children? We don't think you're capable of doing that. And they might lose their children, or suffering in silence in that relationship. And what was being flagged as a result of this report is the English system, sadly, is perhaps failing survivors of domestic abuse as a result of the way it's set up, and as a result of the focus on harm to the children, which, whilst right, did not do enough to look the other way to see, actually, is this a situation where the mother really could do more, could do better? Should we be supporting her to get out? We know that we should be supporting victims of domestic abuse, survivors of domestic abuse. But sadly, again, the UN Committee on the Rights of the Child in 2013 told us that not enough is being done. There isn't enough support out there to ensure that women can break out. So, as I say to you, women in survivors of domestic abuse can find that sadly in our care system, they're in the harrowing situation of choosing between staying in the relationship and keeping quiet, but keeping their children, or speaking up and losing their children. Support is just not there, and it isn't great. We know that we have refuges, we know that we have those services open, but how often do we go to court and the local authority simply doesn't have that resource? I have a case at the moment where I have a 16-year-old mother who provides excellent care for the child, but is in a relationship with the abusive father, is struggling to break free of it. And the social worker solution, social care solution, is to say to her, you need to make self-referrals for domestic abuse work, and we can't rehouse you because we simply don't have housing available. And in those situations, how can this mother and this minor, who is a mother, possibly then break out of this cycle of abuse? Well, it's very difficult. I think we also need to reflect that we're in a system, or we work in a system which is very time limited. We have all of the pressure from the president and from statute to finish in 26 weeks. Often, that is a very short period of time for survivors of domestic abuse to fully break away from their partners. One, we're not sure they'll get proper support in a timely manner, but two, the psychological journey of detaching yourself from an abuser when you might have formed a trauma bond is not necessarily one that we can say that will be achieved in 26 weeks. And often what happens is there is a pattern of falling back into the cycle and then eventually breaking the cycle, particularly if there isn't good support out there to assist you to break the cycle. 26 weeks will not allow for that. You have many, many mothers, many parents who will fall back, and the fact that they've fallen once, they've ended up with the perpetrator again once on one occasion, will be enough for social care to argue, well, they can't protect, they're too vulnerable, we can't trust the child with them, and the child's timescales of 26 weeks means we need a decision now. And again, sadly, we can see how a cycle of being in a domestic abuse relationship can end up impacting on and really harming the right to family life. So, how should the family justice system respond in these situations? And what do we know, our guidance out there, that would mean that we can do better as advocates representing, and even as representatives for the local authorities? So, we know that judges and magistrates have a role in safeguarding vulnerable young people. Of course, they have to consider the overriding objective. Of course, they have to remain independent. But victims, survivors of domestic abuse will automatically be classed as vulnerable people, and the court should be looking out for them. The government's safeguarding policy on working together specifically says that safeguarding is everyone's responsibility. And by safeguarding, I want to flag that we are talking here even about survivors of domestic abuse, because we have to safeguard them as well. That means that when we come to court as either representatives of survivors of domestic abuse, or even the opponents, the local authority lawyers, we need to be thinking about what we will do today in court and what risk that may put for the survivor of domestic abuse, of domestic abuse. If we are going to be cross-examining them on the nature of their relationship and pushing them to comment on certain things, should we make sure that they have a support system and a safety system at the end of that court day in case the perpetrator decides that this is too much, and there is a risk of them attacking that person or being violent with that person. We have to think about whether there should be special measures for these people. We have to make sure that we tackle at a very early stage, and I will say the case management hearing, what support survivors of domestic abuse should be having to help them to grow in insight, to break the cycle and be able to move on. And to that end, the local authority statutory duties from the Domestic Abuse Act 2021 will be very relevant to be flagging very early on in a case. Ways then that we make sure that we discharge our responsibilities. Well, this is not just the court, this is us as advocates and what we should be doing. We should be alert to safeguarding concerns. We should address it in a way that that is proactive, that recognises the issues early. One thing I will say is this: have contingency plans. Things will go wrong in care proceedings. Often there are references and incidents referenced in court papers and in the bundle that will has the potential to leave survivors of domestic abuse in dangerous situations, particularly if they haven't managed to break out of the situation with the perpetrator yet. They may find that certain incidents come up in court that will then make the situation much worse for them when they go home. That perpetrator might be angry with them because of things they've said in the papers, because of how the court hearing has gone, will no doubt try to blame them for certain things. We need to be proactive. We need to have contingency plans. We need to recognise that actually they may need more time in the witness box. There might be a need for breaks. There might be a situation whereby we need to plan safety and check-ins in the night, offer them accommodation, have that ready and available. All of those things that I would say to you are things we should be thinking about in advance. And in particular, if you need it, flag to the judge that in the Equal Treatment Bench Book, it specifically says safeguarding concerns should not be overridden because of the pressures arising in the justice system. You might get judges who say to you, I want a witness template, this witness will only be an hour or two, why do you need half a morning for them then? And if the answer has to be, because we have duties to safeguard them, there are certain risks that will arise during the course of this evidence. We need time to properly plan that and deal with it on the day. Be brave enough to say that, because it might make the difference for that person on the ground when they go home in the night. I want you to also remember that, of course, there are special provisions, and as we discussed earlier, special measures are available for survivors of domestic abuse. We have Family Procedure Rules 3A, Practice Direction 3AA, and in particular 12J, which if any of you do private law in particular, you will know, deals with domestic abuse, and deals with domestic abuse in the context of when the court will have to look at who the child should live with and who they should spend time with. Because in those situations, the court should be consulting 12J. The court should be looking at determining allegations, considering risks that flow from those allegations, depending on any findings made. And in that context, how safely to manage contact between the child and the adult. To that end, I would say that whilst domestic abuse is incredibly serious, the local authority in care proceedings has a duty to flag how domestic abuse links to a risk of harm to children. And we will cover some case law in a moment where this issue has been one that the court has flagged to the local authority to consider. So let's first look at participation directions, because we know that, in fact, from the Equal Treatment Bench Book and from Section 63 of the Domestic Abuse Act, participation directions are open for survivors of domestic abuse. So we can, of course, prevent a party or witness from seeing another one. We can allow a party to witness or participate via live link. We can use a device to help communication. We can provide assistance if they are particularly vulnerable and have, for instance, learning difficulties. An intermediary can assist. We can use screens. We can do evidence by video link. We can have emotional support for them available at court, including having someone maybe sit in with them during the hearing. And we can deal with the structure, the timing of hearing, the formality, and be as flexible as possible. What I would flag here, in addition to these particular measures, is this: you have situations where there are obvious issues in the case around domestic abuse. That may mean that we have to think about what we will cross-examine about. You might have a case where, as a representative, if the local authority or if the guardians team cross-examine on certain particular issues, it will lead to a domestic abuse incident. It will lead to your client being far more likely to be abused at the end of the night. Now, there may be situations where that particular issue is the crux of the case, and whether or not we like it, there will have to be sensitive cross-examination on it. But there might also be situations where, in the grand scheme of local authority of care cases, the local authority's evidence might be so overwhelming that you might want to flag to the judge at a very early stage, in fact, does the local authority need to pursue this particular point? Because if they do, it potentially increases risks to your client, and it might be that the court has to give a ruling to say, no, I don't think I need to hear about that particular issue. I think the evidence on other issues will suffice, and that may then keep your client safer at the end of the night, and that is something that you might want to think about. If needed, by all means request a ground rules hearing, because your client is entitled to participation measures. You might want to think about having that hearing to make sure that we are clear on the structure of giving evidence, what will happen, when breaks will be, what different issues will be tackled, and what will be avoided, as I say, for the safety of your client at the end of the night. I think one other thing I would flag before we move on to case law is Standard 14 of the Ministry of Justice's Witness Charter, which is something that perhaps we don't always come across. But what it does is it requires court staff to make sure that they look at the safety of victims of domestic abuse. And in particular, you can have things like separate waiting rooms. I had to have a case once where the risks were so high to my client that security had to sit in the courtroom to make sure that my client would be safe during the course of giving evidence, things would not be thrown at them, etc., etc. And so you might want to think about those measures and flagging that to the court if you feel that it's a case of that nature. I think that's particularly A, relevant, but B, something that you will find the court has sympathy with, following the recent awful incident of a judge having been attacked by a litigant in person. We all saw that on the news, and the judge being assaulted. And I think the bench are far more understanding about the risks that can come, because sadly, when we do domestic abuse cases, perhaps there was a lack of appreciation of the risks, not only to our clients, but to ourselves. I think that we are every day put in situations of risk, and it is assumed that we will manage clients who are perpetrators of abuse. It is assumed we will manage clients who have emotionally unstable personality or deep-rooted anger issues, including telling them rather hurtful news, and that we will be safe in conference rooms with them, or that we will be fine cross-examining them on these difficult issues and challenging them on these issues. I hope that, and I do think there is a shift now to recognise that actually our safety and our client's safety demands more. So by all means, please flag these provisions. And again, you don't need to write it down, it's in the handout, but it's there for you to use in case you need it. So for the final part of the seminar, I'm conscious of time, and I've done you all of the cases on my handout in a lot of detail. So I'm only going to briefly go through the case law with you because you have it in writing. We're going to look at some of the relevant case law that I think is important for us to note. The first one we will all know, I hope and I assume, is the Reagan case. It's the case that established the rules around, or highlighted the rules around, primary evidence, and the local authority having to prove its case on primary evidence and being in difficulty if it can't adduce primary evidence. But one thing we all should remember from that case is, of course, the fact that we have the society must be willing to tolerate diverse standards of parenting. That's a mantra that's rolled out a lot, but I think it's something worth noting, particularly because in the A case, the words of Judge Jack were endorsed, and in particular, what he talks about is domestic violence. I deplore any form of domestic violence, and I deplore parents who care for children when they are significantly under the influence of drink. But as far as Mr. and Mrs. C are concerned, there's no evidence that I'm aware of that any of that, the domestic violence between them or the drink, has had an adverse effect on the children. The reality in that is that in this country, there must be tens of thousands of children who are cared for in homes where there is a degree of domestic violence, and where parents on occasion drink more than they should. I'm not condoning that for a moment, but the courts are not in the business of social engineering. The reason I flag that is because perhaps there is a culture of moving more towards it being obvious what the risks are should parental relationships involve domestic abuse. But it should not be forgotten that you might come across cases where the local authorities seek to assert that there's an element of domestic abuse, and you might have to argue that actually, even if there is a certain level of domestic abuse, how is it impacting on the children? The local authority still has to link the abuse to the risk of harm to children. I've included on this PowerPoint and in the handout as well the case of Jay, which in itself dealt with that issue again and gave an example of a case where actually it shows that domestic abuse, unless you can link it to significant harm, will not in itself be the ground for removal or a reason to negatively assess a parent. We also have the case of SW, and again, I'm not going to go through this in a lot of detail, but this was a case where a judge made a final care order at a case management hearing, and it went up to the Court of Appeal, and the court said, look, I know we're all trying to do things quickly and to, do things efficiently, but justice must be done properly. And it was a case involving domestic abuse allegations. And if you ever need a judge sort of, what's the word I'm looking for, summarily dealing with issues of domestic abuse, turn to this case, look at what happened there, and highlight to the judge that this takes a bit of time and we should be looking at it more robustly and with proper and thorough scrutiny. HN is the big case that I particularly wanted to talk to you about. Now, HN is a Court of Appeal case which combined 4 different appeals against orders made by 3 different circuit judges. It was a huge case about domestic abuse findings and the conduct of the judge during the finding of fact hearings, or the judges. And lots of organisations joined in. We had various women's rights organisations, CAFCAS, the Rape Crisis joined in, Families Need Fathers, and ALC. They all joined in as interveners to get this right. And the court looked at what had happened in these cases, well beyond, in fact, any particular individual cases, but to try to find a pattern of behaviour that it could identify. All 4 cases, as I say, involved in domestic abuse. All 4 cases raised issues about findings, lack of findings, the manner in which the judges had dealt with the issue, and the impact of coercive and controlling behaviour. I told you we'd come back to that. And basically what the Court of Appeal decided was, look, we need to look at the issue of coercive controlling behaviour differently from how we've done it before. Because, as I said to you earlier, coercive and controlling behaviour isn't just one incident that you can pinpoint. It doesn't even have to be a serious incident on its own. It is about a pattern of behaviour. It should have no legal definition. That's right, because it can be different for every case. But it will involve a pattern of acts encompassing, for instance, assault, intimidation, humiliation, threats. It doesn't even need to be as serious as those. And the key to all of the behaviours is an appreciation of a pattern or a series of acts which, when assessed cumulatively, will have had a debilitating effect, will have been abusive to the person, the survivor, who has experienced this, even if individually they would not be, oh gosh, sorry about that, they will be the kind of thing that one would think, well, this wouldn't by itself be of concern. The Court of Appeal basically said, look, where the allegations are really serious, it'll be obvious that this is really abusive, and the link to harm to a child might be obvious. But with controlling and coercive behaviour, it's less straightforward. And actually looking at an individual incident, a relatively minor one, wouldn't be enough. You'd have to look at the cumulative pattern of behaviours, the dynamics in the relationship, for instance, the power imbalance in the relationship, to see if actually looking at it as a whole, this would have been a relationship of coercion and control. The Court of Appeal also said, look, in a way, Scott schedules are not really suitable then, because in a shot schedule, we all know that you plead a series of incidents and the judge looks at the series of incidents. Actually, what the Court of Appeal said, that is too narrow a focus. You need to look at the relationship as a whole. You need to look at everything that goes on and the dynamics between them. Limiting yourself as a judge to just the allegations of the short schedule might mean that you've missed the point altogether. And so there is a lot more of a focus on a holistic and fuller understanding of the dynamics in relationships to establish coercion and control, which was something that previously we would have looked at in Scott schedules and perhaps not have had a full appreciation of, whereas now the analysis needs to be much wider than that. So HN is a good case if you ever need that. HN is a good case for you to understand that actually pleading particular instances might not be the right way to do it. I think what I would say, though, is that the Court of Appeal didn't give any guidance, in fairness, as to what the alternative is. If not a Scott schedule, then what? And by Scott schedule, I also mean, for instance, threshold documents, because they are semi Scott schedules, because they list the allegations in the same way. I think we need to be more clever with how we plead things. And we may need to find that what we are pleading is, over the last 5 years of the couple's relationship, the relationship has been characterized by coercive and controlling behaviors, with the father exerting this over the mother. He has done this through, for instance, a series of behaviors that demonstrate financial abuse. He has limited the amount of money the mother has had between X year and Y year. B, isolating from friends. The father has stopped the mother from seeing her grandmother, then her friend, then this, then that. C, he has gone through all of the mother's social media accounts over many years, including when she asked him not to. And so what you do is, rather than establishing this particular incident, you are showing things that have been happening as a repeating pattern over many years. It might well be that is the way we have to do that. And certainly that is the way I plead it now, because Scott schedules, individual incidents, are too narrow. We need to think about overall patterns and plead those over many years to really get to the bottom of coercive and controlling behavior. Let's talk about the case of AA and BB. So another case. Now, Mrs. Justice Judd, if you ever see a case of domestic abuse from Mrs. Justice Judd, she's the lead for this issue in the family court. So you want to focus on those judgments, because you'll get a lot of wisdom from her in terms of what she says should happen. And really what she'd done in this case was she'd allowed appeal in private law, dealing with a number of allegations to investigate in scope of the evidence. What had happened in that case was, the mother had made her allegations, and the parents were limited to the amount of allegations they could make. Just before the trial, the finding of fact was to start, the mother filed a lot more allegations and said, look, all of this is relevant. And the recorder decided, on application from the father, that no, I'm going to exclude those. It's not right for you to pursue that. The hearing, the finding of fact hearing, had to go off for other reasons. So they had another bite of this anyway. And at that point, the mother filed an appeal to that decision and said, look, I think all of my allegations should be determined. The reason I flagged that history is to flag that, in fact, there wasn't an issue around last minute fairness in this case, because the finding of fact had to go off anyway. So even if she'd filed the further allegations, there was time for the father to properly respond to that. Mrs. Justice Judd looked at it and said, look, in the back of REH, HN in particular, we need to be thinking about the fact that we can't limit allegations in this way, or we will miss the point when it comes to the nature and dynamics of relationships. If the mother says that there are other allegations, in particular there were allegations like the father having hit the child, that is absolutely relevant, and the father will have time to respond to it, because the finding of fact hearing is going off anyway, and so she should have the opportunity to pursue that. So that's what the judge decided. But I think it's right to flag that the judge also said, look, the reality is, though, there will be occasions where if things are filed last minute and they would scupper the fairness of these proceedings, they may need to be excluded. So this isn't an open, you can file things last minute, you can raise last minute allegations. This is still saying you need to think about fairness all round, but also don't be so willing to dismiss what are obviously serious and relevant allegations. Return to another case I want to flag to you. That's the case of M. Bear with me a minute. I'm just trying to find it on my handout for you. So private law proceedings. This is Justice Judd. Yes. So this case dealt with indecent images. So I say indecent, intimate images. So nude images. That is something that sadly comes up a lot, particularly around allegations of rape, sexual abuse, and online abuse, the posting of images and videos online. And the question is, well, what do we do about that? Can you just file those things in proceedings? Because I know as lawyers, you will already have a hesitancy around that. The answer is that Mrs. Justice Judd says, look, some of this might be relevant, but if it is, you should make an application to the court in advance before filing it, for the court to determine why it is relevant. You should explain what it is you are seeking to file and how it is relevant to the proceedings, because of issues of confidentiality, because of issues of making sure we don't just throw everything in. We don't throw, as she has said in another case that dealt with this issue, we don't throw the proverbial sink into court. We have to make sure that we justify what's relevant, and then it can be filed. There's no presumption that things will not be filed or that they will be filed. It is a case of making sure that it is relevant and necessary, and it can then be dealt with. The case of A and a nor. It says A and D and B on others. So in that particular case, again, we're dealing with Mrs. Justice Knowles, and what she says in this case is this: look, she was invited in this case to define what consent would look like in family cases. We know that in crime, if you have allegations of rape, there are certain defences that can be deployed or deployed by the jury, by the defence for the jury to consider. And the question really was whether in family law, can you have the same system? Can certain defences be brought up, and should we define what those defences are? I don't know how many of you will be familiar with Miss Justice Russell's judgment in JF and MF. Miss Justice Russell sits in the family jurisdiction, but actually sits in the criminal jurisdiction as well. And she had decided in that case that, look, there is no sensible reason why we should have two different sets of legal concepts. In crime, we have certain concepts, and actually it makes sense for family to have similar concepts, which one might think would mean that in a case like this, defences in rape in the criminal jurisdiction could be directly applicable in the family jurisdictions, and we could define those and say these are defences to rape. In fact, Mrs. Justice Knowles decided against this, and she said, no, actually, family law is different to criminal law. Actually, we look at things far more holistically, and what is a defence, or what might justify and show that there was consent, or might justify why one behaved in a certain way when allegations of rape are made, is fact specific. It will depend on the case. And she declined to provide specific definitions of defences that we should be following. I think that's useful for us to know. So, yep, I've dealt with that. The other thing, again, she flagged is the issue of intimate images and bringing out people's sexual history. And she says, look, if you're going to do that kind of thing, you have to apply for permission and explain why it's relevant and necessary at a case management hearing. Again, these are the kind of things that, because they go back to rape myth culture around, for instance, sexual history and behaviours, we shouldn't really be entertaining them in the family court. And what she says is, look, if you're going to be relying on this sort of thing, don't just file it, apply and tell me why it's relevant and necessary first at a case management hearing. And if I decide that it is, then I will allow you to file this evidence. If not, it should not form part of the proceedings. So that's something worth noting. I think finally, and it is my final case that I want to talk to you about, is the case of Rief. It's an old case now. It's a case from 2018. Gosh, imagine that being old. I remember when that first came out, showing my age. I always rely on Rief if you are for a parent. And if you are for a parent who actually has a lot of positives to them, but have ended up in a domestically abusive setting. This case was a case with a young lady, I think she was 33 at the time, and she was vulnerable. She was in a domestically abusive relationship, and she had had herself an abusive childhood. As a result of that abusive childhood, she, of course, went for the wrong kind of man. We see certain patterns repeating itself, don't we, in these types of cases. And what happened was she had ended up dependent on alcohol. But when they did a psychiatric assessment of her, the psychiatrist came back and said, look, this isn't a dependency on alcohol. This is her dependency on alcohol is linked to being in an abusive relationship. And therefore, if she leaves that relationship, she's going to recover from this issue. During the course of the proceedings, the local authority had initially filed a plan because her contact was excellent. She'd looked after this child for around 11 months with no criticism of her care, apart from the issue of A, alcohol, and B, the father, and the risks posed by him and her intertwinement with him. So the local authority had filed the final plan saying, look, child should be with her. Then they had had some evidence uncovered because the Guardian asked for further evidence to be gathered, which showed that in fact she had remained intertwined with the father and in breach of the written agreement. The local authority then filed a placement application, and final care and placement orders were made. It went to the Court of Appeal, and the Court of Appeal took a different view. The Court of Appeal criticised the mother. They said, look, she was dishonest. She was dishonest about her relationship with the father. And actually, she did things that she shouldn't have done if she wants to work with professionals. He's a real risk, and we need to recognise that. But the reality of the situation is this is a mother who doesn't suffer from serious mental health problems. This is a mother who doesn't have addiction problems. This is a mother who has lots of positives around her ability to care for her child. And before we go down the really draconian step of adoption, should we not do more? by way of trying to make sure that we can work on her with the issue of domestic abuse, make sure we justify that she's had proper support services put in place, and give her further time to demonstrate change? Would that not be the proportionate response before we adopt a child out? And so it is a useful case, I think, to always be flagging to the court, because certainly when the argument will be raised, timescales for the children, 26 weeks, she's had her chance and she failed once, she went back to him. We will want to be able to say to the judge, look, it's perhaps unsurprising that a survivor of domestic abuse has relapsed, but actually, can more be done? Should more be attempted if there are lots of other positives around this parent before we go down the path of adopting a child out forever? So a useful one if you represent parents, one that I have relied on several times in those types of cases, and one that, even though from 2018, I would say is still very relevant for you to note. And so that is the end of the seminar today. We looked at today understanding domestic abuse in the more wider sense of the obvious definitions that we see. We looked at what the family court should be doing to support survivors of domestic abuse, and we covered some of the relevant case law to make sure that we're up to date on where things are at. Those aren't all of the cases, I would say. There are many cases on domestic abuse, but that gives you a good start into it, and there are a couple more on the handout for you to note as well. Thank you very much for listening. Does anyone have any questions? You can pop it in the Q&A box. If not, I will let you go for the evening. But I'll first check the Q&A in case anyone has any questions, or the chat box. Oh, someone's put one. Could I ask what measures are available to disabled survivors of domestic abuse sexual or litigants in persons in private proceedings when the aggressor has an extensive legal team? Okay, so the court has duties to safeguard litigants and people in proceedings, vulnerable people, so domestic abuse survivors, and also to safeguard litigants in person. So what you want to be doing is flagging that, well, I suppose you can't, but what you want to be informing any litigant in person who will end up in that situation is that they should be raising with the judge the disparity of power here, and the fact that they feel uncomfortable giving evidence in a certain way. And the court should be considering how they could achieve this fairly for that individual, how they could manage such a difficult situation, particularly if they are a survivor of domestic abuse. They may be entitled to video link attendance, questions being monitored in advance. They may be entitled to the opportunity of last word, even though they are the ones making the allegation. And so you want to be flagging all of the participation directions that we have spoken about, and the practice direction 12J and what that says around how to protect vulnerable individuals. I hope that assists. Do we have any further questions? I don't think we do. So I will say thank you very much for attending. If you do have any questions, please do email me if they come to you afterwards, and otherwise have a good evening.